It's The Law with Morelli Chertko, and joining me this afternoon is Rachel Lammers, whose area of expertise and practice is estate and family litigation. Today we're discussing wills variation claims. And first of all, Rachel, what is a wills variation claim?
Well, a wills variation claim is a lawsuit that is started by a spouse or a child of someone who has passed away for an interest in that person's estate or a greater interest in that person's estate.
Okay, so what are some of the reasons that a court might vary or change someone's will?
Well, there's really two reasons why a judge would change somebody's will, and it has to be either for a legal reason or a moral reason. And in law, those can mean many different things. A legal reason might be an obligation to take care of a minor child, for example. If somebody passes away and their will didn't make a provision for their to take care of their child, that might be a legal reason to make a provision in your will for your minor children. It's a little different with adult children. That might not be a legal reason to make a provision for your adult child, but there might be a moral reason. And that can be many, many, many different things. A moral reason might be, for example, if an adult child is disabled or has a certain financial need, or perhaps that adult child was very helpful to the testator. A testator is the will maker during their lifetime, or there might be some imbalance of favoring one child over the other for no reason that a court would support.
So does the court always vary wills?
Not always. Wills are only varied if there are valid and rational reasons for doing the things that the testator did, and that's can mean also many different things. If a court questions why a child was disinherited, court might inquire into why was this particular child disinherited. If the reasons for that disinheritance aren't true or valid, for example, the person said, "Oh, my son Bobby was stealing from me throughout my lifetime," and in fact that wasn't really true. It was mistaken information. A court might say, "Hey, that's not a valid or rational reason to disinherit Bobby," and might change a will to make provision for that child.
Okay, but shouldn't the will writer or testator's wishes just be respected?
We call that in law testamentary autonomy, and it means the right to do what you want in your will, basically is what that means. And it's an important thing, and courts do look at that also. What a person wants to do with their worldly goods is important, but it isn't the only thing that a court might look at in a wills variation case. It's one of many considerations, and the court has to balance these different interests of moral and legal obligations with a testator's right to do with his or her estate as he or she wishes.
So what types of assets are included in a wills variation claim?
Well, anything that is in an estate can be subject to a wills variation claim. It's actually called the Wills Estate Succession Act now, but we still call them a wills variation claim. Things that are in an estate can be anything. It could be vehicles, bank accounts, property, anything at all, but some things are definitely not part of an estate, and those would be anything that passes through a beneficiary designation, like, let's say, a life insurance policy or an RRSP beneficiary designation. Those kinds of things, we call it pass outside of the estate, as do property that's held in joint tenancy, we call that, where there's a right of survivorship. For example, if the testator owns a house with his spouse and the testator passes away and the house is owned in joint tenancy, it just simply goes to the other spouse and doesn't form part of the estate. Bank accounts can work the same way as well.
How could I bring a wills variation claim?
Wills variation claims are tricky. They can be expensive. And so it's the kind of thing that you ought not do on your own. It is the kind of thing that you ought to talk to a lawyer about. Our firm does many of these types of claims and is well experienced in them. You really do need to talk to a lawyer if you want to bring a challenge to Wills Variation Act, Wills Variation claim. But But one thing's really important. There's a strict time limits for these things. There is a 180 days is all you get, about 6 months, to bring your claim from the date somebody gets what's called a grant of probate. That might sound like a lot of mumbo jumbo, but the main point is don't wait. If you have questions or about this type of a subject, get into a lawyer as soon as you can, because there are time limits.
Rachel Lammers, Estate and Family Litigation and Wills Variation Claims. It's the Law with Morelli Churtko.